Hi, my name is Jane McElligott. I'm a faculty member of the School of Legal Support and Services here at Purdue University Global. And I'm going to share with you a summary of Alexander versus South Carolina Conference of the NAACP, just decided last week, May 23rd, 2024. So this is there's a lot of cases starting to come down now at the end of the 2023-2024 term. And this is actually a major decision. So it involves what is referred to as gerrymandering, a form of redistricting a congressional district that becomes extremely partisan. And in this case, not only partisan, but it is allegedly race-based as well. This is a picture, this kind of shows the origins of the term gerrymander. So Governor Eldridge Gerry of Massachusetts, way back in 1812, approved this new redistricting map. And the legislature wanted to get, they did some very creative mapping here to ensure that they had a Democratic stronghold. But this is kind of an example of extreme gerrymandering, and so extreme that it looked like a salamander, and hence the name gerrymander. But that's what often happens in these cases. The district takes on a very odd shape because the legislature is really moving people around to get the most advantage for their party. Uh, and so let's go ahead and take a look at the facts in this particular case. So again, this is in South Carolina. So in the 2018 election to Congress, Joe Cunningham was the Democrat who won District 1, and this is the major district in dispute in this case. This was an upset because this district had been a stronghold for Republicans since 1980, so several years. Nancy Mace then came in and defeated Cunningham in 2020, but only by about 1% of the vote. So it was very close. So the Republicans were determined to change this around to get a stronger hold on this district. So following the 2020 census and looking at the demographics, the Republican controlled South Carolina state legislature decided to draw new lines, so new district lines. This is in 2021. And they did a lot of line drawing and moving people around to the point where they actually removed 30,000 Black voters from District 1 and sort of sorted them into a different district, into District 6, which was already very Democratic, a Democratic stronghold. And the representative there, who won term after term, was James Clyburn, who was a Black Democrat. So you can see a lot of maneuvering there by the state legislature. So the NAACP challenged this newly drawn District 1 and accused the legislature of intentionally sorting out Black voters from the district for its own advantage to win the elections in the future. The NAACP argued that race, not partisan politics, was the primary factor in the redistricting. And of course, if this is true, this would be a major violation of the 14th Amendment Equal Protection Clause and the 15th Amendment prohibition against denying or abridging the right to vote on account of race. So this case then was heard by the federal district court. Extensive trial, 9-day trial. The justices, it was 3-judge panel. They went through reams of statistical data, firsthand witnesses, those who had worked on the maps, for example, testified. Expert witnesses on politics and map drawing came in and testified. Great, just an enormous amount of evidence to sift through. And after all this analysis, the court ruled that the new map was an unconstitutional racial gerrymander. So that the trial court decided that yes, those who drew this new district were clearly looking at the demographics of race, not just whether someone is Democrat or Republican. And this is, again, based on reams of evidence. In fact, the court said that the gerrymandering in this case was so extreme that the court called it a bleaching of African American voters from the district. So the court's ruling was then placed on hold pending review, and the thought was that SCOTUS, Supreme Court of the United States, was going to review it back in January and maybe make a decision quickly after that, but they dragged it out until just May for its decision. So the result of that is that this current map that strongly favors the Republican legislature and Republican voters is going to stay in place for the 2024 election. And even worse than that, it really, as we'll see, the majority opinion written by Alito sets a extremely high standard for anyone who wants to challenge gerrymandering as race-based. So we'll take a look at what that challenge is. So Justice Alito, again, he is the one who wrote the majority opinion in this case, and he overturned the federal trial court's ruling, finding that the trial court's ruling was clearly erroneous. Now, this is a major contradiction of the regular course of proceedings that judges follow, appellate court judges, whether we're talking Supreme Court or Court of Appeals, give deference as a matter of practice to the trial court, because the idea is it's the trial court that hears all this testimony, sees all this evidence firsthand. They're the ones, the judges in the trial court can look at the credibility of witnesses. It goes through these voluminous uh, exhibits, and so they're seeing it all firsthand. So for an appellate court to just kind of look at the transcripts and say, "Oh no, you were clearly erroneous," that's quite a big, a major change from the way the court usually does things. And so once he declared the district court's findings to be clearly erroneous, he then went on to re-examine the facts himself and reached really a diametrically different conclusion. So he ruled in favor of the state, and he said that the South Carolina redistricting map was the result of partisan gerrymandering. So based on, there's that we need more Republicans basically in this district, and that is legal. It's ethically, it seems a little fishy, but it's legal. It's not unconstitutional. Um, and he said it's partisan, that this was partisan gerrymandering, not racial gerrymandering, which of course is not legal. So interesting, Alito displayed really what the commentators referred to as his dismissive attitude toward any allegation that racism might exist in the American government. He just was not willing to consider that the South Carolina legislature perhaps considered race in its redistricting. And so his opinion, in his words, he said, when a federal court finds that race drove a legislature's districting decisions, it is declaring that the legislature engaged in offensive and demeaning conduct, and we should not be quick to hurl such accusations at political branches. So he's pretty much saying that we just shouldn't go there. We shouldn't hurl these accusations, which is a very kind of hands-off approach. Usually, when a challenger challenges something that the state does, both have an equal burden. We don't have this presumption of innocence by the state. So he has really kind of set a new standard here. And the problem with this is it's likely to give the green light to state legislatures who use race as a proxy for partisanship. So while they might say it's partisanship, they're really basing it on race. The demographic of race really could come into play. And even, the statistics are showing that in South Carolina, Black voters, 90 to 95% were voting Democratic. But there are also differences. For example, they found that Black voters tend to go for the Democratic candidate every time, whereas white Democratic voters sometimes would switch sides depending on the candidate. So they were looking, and this was brought out in the evidence at the trial court. They were looking at these factors. They were considering, the legislature, that is, the racial demographics as well as the politics of it. So Alito, as one commentator has put it, Alito gives the court's blessings to maps that are drawn for the very purpose of maximizing one political party's power. And in Alito's words, as far as the federal constitution is concerned, a legislature may pursue partisan ends when it engages in redistricting. Now, this really has never been said by the court before, that there's always been sort of a tip of the hat to it that, yeah, I guess partisanship goes on when redistricting. But the court has never stated that it's fine to go ahead and completely be partisan. This case adds to that by saying not only can it be partisan, but it's going to be mighty, mighty difficult to prove that race played a factor in it. And so, really, another commentator has said that rigged maps now enjoy the Supreme Court's unambiguous support, which is a totally new aspect. And then on top of that, when state legislators are challenged for engaging in racial gerrymandering, the legislators will now benefit from a presumption of legislative good faith. So that, of course, makes it a much higher hurdle for challengers of gerrymandered maps that have been crafted by legislators who have used race as a proxy or a substitute for partisanship. So in this particular case, Alito held that those challenging the gerrymandering of District 1 should have an adverse inference placed against them for failing to provide a substitute map that shows how the state could have achieved the same legitimate political objectives while producing greater racial balance. So he's kind of putting in this new requirement in a sense. I mean, he's not saying it as a requirement, but he's saying that if you don't produce this map, there's going to be an adverse inference against you, which is not good. So he's basically saying, come in and show us a map of how the legislature could have done it without involving race, which is a very high hurdle. So first of all, he sets this presumption of racial innocence in favor of state legislators, and then a requirement that the challengers should produce their own map to show how the state could have achieved the same partisan goals. So this, again, mighty high bar that's set by Alito. And what the result of this is that it is likely to lead to unchecked proliferation of racial gerrymandering, in which legislators use race as a proxy for politics. And so this case, it was sent down to the district court again, remanded. And it is possible that perhaps, I mean, that they have another chance to show that race was involved. But, this is a major setback, and this map is going to remain in effect for the upcoming 2024 election. The Alito referred to the case of Cooper versus Harris 2017, but it was Justice Kagan in her powerful dissent who really pointed to this case. So in Cooper, the majority of Supreme Court, SCOTUS, held that the sorting of voters on the grounds of their race remains suspect. So, very high level of suspicion there, even if race is meant to function as a proxy for other, say, political or partisan characteristics. So while Alito really didn't make much of this previous decision, this precedent, and didn't explicitly overrule it, Justice Kagan pointed out that in this Alexander decision, the court has in effect overruled Cooper. To talk a little bit more about Kagan's dissent, she was joined by Justices Sonia Sotomayor, Ketanji Brown Jackson. So the three of them versus the six in the majority. But Justice Kagan, again, very powerful dissent, really kind of criticizing Alito's decision all the way through. And basically, she said that Alito ignored the requirement that the court is to give the district court's findings significant deference. And that was one thing that she I think very well hammered home, that that's an important standard, that if the as long as the district court's findings were plausible, then the Supreme Court should give significant deference, and that Alito did not do. And so Kagan went into the evidence that was presented at the district court and brought in many of the statistics, the convincing testimony, the questionable testimony by some, and said that, and her dissent was as long as the majority of the opinion of the court in this case, because she really sifted through all the evidence. And she said that there is more than enough evidence of racial gerrymandering to support the district court's judgment. So she accused the majority, Alito, of substituting his own judgment for that of the lower court. And this is even on questions of the credibility of witnesses, which, again, an appellate court judge, they're not there. How can he really assess the question of the credibility of witnesses the way that a judge could do sitting there in the trial court? Kagan also criticized Alito for his newfound presumption in favor of state legislators. Again, this is a new thing. He had actually brought this up in his dissenting opinion in the Cooper case that we just looked at, but never has a majority of the court ruled that there's some kind of special presumption in favor of state legislators when they're challenged. So his presumption, again, that they must have acted in good faith when redistricting, and then on top of that presumption, the imposition of an adverse inference if the challengers failed to submit some alternative map. Together, these really create serious hurdles for challengers of racial gerrymandering in the future. I think her dissent did a great job of summing up pretty much all that's wrong with the majority's opinion, and summing up the impediments that Justice Alito set in this opinion for future challenges. And she said, in every way, the majority today stacks the deck against the challengers. And usually the challengers are, say, in this case, it was the NAACP. It was a particular voter. It was a Black voter in the district who finds that, who contended along with the NAACP that this was race-based gerrymandering. So when racial classifications in voting are at issue, the majority says every doubt must be resolved in favor of the state, lest, heaven forfend, it be accused of offensive and demeaning conduct. What a message to send to state legislators and map makers about racial gerrymandering. Those actors will often have an incentive to use race as a proxy to achieve partisan ends. And occasionally, they might want to straight up suppress the electoral influence of minority voters. Go right ahead, this court says to states today, in the electoral sphere, especially where ugly patterns of pervasive racial discrimination have so long governed, we should demand better of ourselves, our political representatives, and most of all, this court. So very powerful words from Justice Kagan and the other two who joined her that really make it. And I think this also shows how important it is to, when you read a Supreme Court decision, always take a look at that dissent, because the dissent is going to, you might read the majority and it sounds good, but that dissent is going to pick it apart and perhaps find things that are mighty questionable. So that is all I have for this one. There are a lot more decisions to come in the next month or so into well into June. So I will be back with more. And here are some articles that I found very helpful. Of course, SCOTUS blog is always a great spot to check for court summaries. And there's just a couple. I like this one by Millhiser. The Supreme Court's new voting rights decision is a love letter to gerrymandering. So they all do a good job really analyzing this case. But take care, and I will see you again.